Hello, everyone. Welcome to today's webinar on giving children a voice. We're so honored to have you join us. My name is Kendall Seal, Vice President of Policy for the Center for the Rights of Abused Children. And I'm joined today by an esteemed panel of experts who are really excited to share with you. There will be an opportunity for questions at the end. Please feel free, ask away. We want to get as much information and respond to your concerns and curiosities with this topic. So that will be held toward the end. But let's go ahead and get started. I'm going to start our PowerPoint. Giving children a voice. So by way of background, the topic of client-directed counsel, many of you may know about this topic already, but just to kind of give everyone a level set, I'm going to introduce the topic. Around the country, 50 states, what we're looking at, 13 states have nothing for children in terms of advocacy. We have 10 states that have client-directed counsel. That means they're fighting for the expressed interest of the child. And in between those 13 and those 10 are a range of different representation models across the states. We have states who have hybrid models with client-directed representation. We have states with exclusive guardian ad litem representation, where they're advocating on behalf of the best interests of the child. And then we have some with non-attorney GAL models across America. And so the issue that the center puts front and center and highlights the gold standard and what today is about is that client-directed model. And we'll get into why that's important here in a bit. But one of the big issues that comes up, and you'll hear probably our panelists talk about it, are, well, what about if the child is really young? I mean, how do you know a child's wishes? How is that communicated? That comes up a lot. And each jurisdiction kind of navigates that in a unique way. But one of the big ways that that happens, and practitioners across America are familiar with kind of how to navigate this, is that it's the substitution of legal judgment. So that is to say, an attorney substitutes their legal judgment on behalf of the interests of the child when representing them. But why? Why does this topic matter in abuse and neglect proceedings? For starters, children move through the system at 1.7 to 3.5 times faster when they're represented by client-directed counsel. And it's not just that issue. There's a whole range of benefits when children are represented by client-directed counsel. You can see here on the screen everything from reunification to fewer placements, fewer moving through in and out of schools. And what we know is, like, when children move right from a different home or they move schools, that has negative consequences for children. And so that's why it's really important that we try to promote stability, and client-directed counsel is part of that stability. When we talk about a reform on client-directed counsel, these bullet points on the screen kind of highlight the significant areas of focus that we look for in these reforms. The big one that I would focus on is that for the center, we don't believe there should be an age limit when it comes to client-directed representation. And that's one feature that we look for in reforms. The second, we look at that clarification on substituting judgment, or kind of focusing the court's attention on what it means to substitute legal judgment. Structural issues within the child welfare system, particularly when it comes to representation, are another opportunity lane for reform. And finally, enhancing and promoting collaboration, continued education, and kind of leveling up when it comes to the quality of child welfare representation. Now, I would say our colleagues on NAC have a wonderful program. Their Red Book, their training, their certification is a great tool that I'm certain some of them will be talking about later, but that's another great opportunity. So these are the areas that we frequently hear about from policymakers as reasons that they're interested about client-directed representation. They want to center the child in the case. They want to give a child a voice. What about system accountability? And a lot of times in the states, we talk about how we partner this or match this with Foster Youth Bill of Rights, and how client-directed counsel, when matched up with Foster Youth Bill of Rights, can really strengthen and enhance a child's voice in the system. Lots of questions usually come up around conflict of interest. More recently in Kansas, for example, they were talking about shortage of counsel, which for them, particularly in the frontier counties, is an ongoing issue. Confidentiality in these cases, funding. You'll hear about Title IV-E funding, and what we know across America is that a lot of places, they're not pulling down Title IV-E funds for even the guardian ad litem model, much less the client-directed model. So that is an opportunity for conversation. And then finally, there's a lot of focus on structural inefficiencies and barriers to zealous advocacy in the child welfare space. So these are all the main kind of questions that we've been fielding across the states this year. I wanted to give you a snapshot of what some of the legislation is. We have movement in Kansas and Missouri. I'd point you to the Missouri bill in particular that has an interesting structural fix related to an Office of Child Representation, has moved out of committee. I know my colleague Allison Green and I have been talking about what Title IV-B reauthorization opportunities lie there. There's a new federal rule that's not been released yet, but there's definitely been comment period already on it, primarily focused on pre-petition work, but expanding opportunities there for client-directed representation. And I have a category here on partial offense. And what I mean by that, it's not kind of our full-fledged client-directed counsel for all focus, but there's definitely headway being made in Iowa, particularly around the age of client-directed representation. And then in New Hampshire, focusing on group homes. There's a drive there to give courts the discretion to appoint counsel, but also to look at those youth in group homes who need that advocacy. And then some defense that we've been playing, in particular in Florida, where they currently have client-directed counsel, but there has been a push there to kind of roll back those rights for children. And that's been found in Senate Bill 1224. There have been some amendments. I think there's been some positive amendments there, but my colleague Annalise will be diving into that conversation. Now I'm going to share with you some testimony by Stormy Lucas Savage. Stormy serves actually on the NACC, the National Association of Counsel for Children, Advisory Ambassador Board for Foster Youth. But Stormy's testimony was particularly compelling for us, and I wanted to share it with you today.
Thank you for being here.
Thank you, Madam Chair and members of this committee. Yes, I am Stormy Lucas Savage. Ultimately, I am a lived experience expert, but much more importantly than that, I am one of those foster youth that came from this great state of Kansas. And ultimately, I am here today partially because my legal team failed me. And it is through those negative experiences that I share a part of my story and why I advocate for client-directed representation. I advocate for client-directed representation because to me, to enter a system within a few minutes, your whole life changes so drastically that you don't know what happened and you are entering a system with no idea where you are going. My legal representation throughout my 3 years of foster care experience, I only met them at the initial onset of me entering care. And because I did not have that adequate legal representation, and because I could not offer what I wanted for my case, it led to me being put in a very dangerous predicament. The system ultimately tries to align youth with their back to their biological families. But my stepfather was a 6'7" abusive monster that the state tried to push me into going back with. And because there was no one, no legal professional to ask me what I want or to offer me a safe space to offer my opinions, it led to my self expression through horrible self mutilation that ultimately almost ended up costing me my left arm. And it is through those experiences that I can offer that this isn't unique. I ended up graduating and leaving foster care from a group home where most of everyone that I encountered had the similar experiences where their legal representation failed them. And most of those people from the same group home are either locked up, homeless, or deceased. It is a sad fact of life that was validated through my experience interning at Shawnee County Jail, where one of my students came up to me and offered that he was my best friend from the same group home that I exited out of care. So to me, client directed representation is the only tool that foster youth have to be able to voice their opinions in a system that they don't have any control over. To be stripped of their decision making is ultimately an offense to their God given right to self expression and their ability to be human. Ultimately, there needs to be that level of accountability for these youth who so easily fall through the cracks. And that is why I offer my opinion.
I was so inspired by Stormy's testimony that day, and I know it spoke to a lot of policymakers. And so I'm constantly in this role inspired by youth. I'm inspired by my colleagues, and it was so brave of Stormy to do that. And so I just wanted to say thank you to Stormy for that. I'd like now to kind of move and introduce our panel so we can get to some questions. Allison Green, Legal Director for the National Association of Counsel for Children. She manages the organization's policy advocacy. Previously, she served as Foster America Fellow at Missouri Children's Division and a senior supervising attorney at the Children's Law Center in DC. She's a certified child welfare law specialist and has volunteered as a CASA. Also today, Tom Jose, lawyer who protects the rights of abused children throughout the foster care process and beyond. He heads up the center's pro bono children's law clinic, where he represents not only abused children, but foster parents, kinship placements, and bio parents. Tom's passion started out working for an appeals court shortly after law school. He subsequently worked for the Arizona AG's office. He handled hundreds of appeals, filed over 75 substantive briefs, multiple oral arguments in front of the Arizona Supreme Court. In 2020, Tom was given the award for outstanding appellate advocacy. Thanks, Tom. Tim Keller, a lawyer who works to ensure all abused children and abandoned children are safe and have an access to their constitutionally guaranteed rights. Tim, as you probably saw, was the author of the recently released kind of handbook, really, on children's constitutional rights. You should check that out on the center's website. But before joining the center, Tim worked for nearly 20 years at the Institute for Justice. He served as lead counsel in Arizona Christian School Tuition Organization versus WIN. That was a U.S. Supreme Court victory that protected Arizona's pioneering school scholarship program. He also led the team that secured a U.S. Supreme Court victory in Espinoza v. Montana Department of Revenue. Tim and his wife, Lisa, don't just, embrace this work. I mean, I should say Tim doesn't just embrace this work professionally, but together, he and Lisa embrace it personally. They're foster parents today. They offer respite care for children in foster care. And if you have the chance, you should check out Gus, their dog's Instagram. He has like 12,000 Instagram followers. So welcome, Tim. Nellie Washington, in January 2021, she joined NAC as their policy counsel for their Counsel for Kids campaign at the state level. The campaign influences and drives policy change to ensure legal representation for all children experiencing foster care. She has over 10 years of experience. She was a policy administrator in Georgia's Division of Family and Children's Services, Director of Operations for Fulton County CASA, and Senior Child Advocate Attorney at the DeKalb County Child Advocacy Center. Now, Lisa is also a child welfare law specialist since 2015. Really honored to have you all here. Let's get started. I'm going to stop sharing, and so we will have remarks made by each of the panelists. I'd like to start with Allison.
Hello, everyone. It's great to be with you today. Thank you for to Kendall for kind of starting us off and giving an overview of this topic, and also especially for grounding us in Stormy's testimony. I think that's the most important place we should be looking when we think about this issue, looking at what do young people tell us that they need from their attorneys. In many other fields of law, attorney work in the field has become very client-centered, right? If you work for a big fancy law firm and you're representing corporations or adult clients, you're trying to get business and you're trying to say, look at your client community and say, what do they want and need for us? And we need to think about, what does our client community want and need from us and for their attorneys? We are on a mission day in and day out to fight for counsel for kids. Natalie leads our work on the state level in those 13 places Kendall mentioned that still do not have any guarantee of an attorney, regardless of model. And then we're also working with many organizations, including the Center, on our federal advocacy to try to enshrine in law an access to counsel statute that would guarantee lawyers for children and parents who are experiencing court proceedings. Because what we know is that when a child comes into foster care, everything is at stake for their entire family. And though it's traditionally been thought of as a social work system, social workers are incredibly important, but it really is a marriage between two disciplines, social work and the law. Civil rights are at stake, so lawyers are needed, and we're happy to be here with you today to talk more about the pathway to getting there.
Thank you so much, Allison. And just as a reminder to those listening in, you can ask a question at any time. We're monitoring that. Next, I want to toss it over to Tom.
Yeah, I just want to speak a little bit about my experience working in the Phoenix area after we changed to a client-directed model from a GAL model, and that I think the representation for children got qualitatively better. I mean, we've seen all sorts of numbers about how they leave the system more quickly, and all those other good things, which are all true, but I think the quality of representation went up when attorneys are working within the rules, meeting their clients, meeting collateral contacts. I think it leads to a more thoughtful representation of the child, which leads to not only quicker exits and better permanency, but just better outcomes throughout the process, what may come. And I think we saw this in Arizona, especially on appeal, where previously GALs essentially did nothing on appeal for the child. They didn't file anything. It was hard to even get, if you were trying to do a motion, to get any answer out of them if they, opposed or anything like that. But we've seen, especially in Maricopa County, we now have one of our government law firms representing children has a dedicated appellate attorney, and we're seeing a lot more attorneys filing briefs on behalf of children, and we're seeing the courts address those arguments. So we're seeing a very real impact from client-directed counsel that we didn't have when we had GALs.
Thank you. Thank you, Tom, for that kind of frontline experience on what it's like to kind of make that move. Next, we're going to pivot over to Natalie's.
Thanks, Kendall. Hello, everyone. Natalie Washington, Policy Counsel at NACC. I'm so glad to join this conversation, primarily because my work is centered at the state level, where I work to affect policy change to guarantee the rights to counsel for youth in foster care. And one of my primary focuses is securing that high quality legal representation for every young person engaged with the system. And for me, that means that not only are we obtaining a statutory guarantee, a change in law, but we're also ensuring that there are standards of practice, training requirements, reasonable caseloads, centralized offices where there can be accountability and supervision of practitioners, all to ensure that we're not just getting a right for the sake of the right, but ensuring that the legal representation that is guaranteed is of high quality. And we do that with a focus on amplifying youth voice. And so I'm so grateful to you for involving Stormy and hearing his voice, because that's what we'd like to see at every state legislator level as they are considering policy changes. So thanks for having me here today.
Absolutely. I'm so excited about this conversation. Last but not least, Tim Keller.
Well, thanks for letting me bat cleanup here, Kendall. I really appreciate the focus on centering children's voices. I approach this with the thought that children have a constitutional right to be heard and to participate in their own cases. And ultimately, I believe that that right leads to a conclusion that children have a constitutional right to be appointed legal counsel in their cases when they are taken from their home and they are placed into foster care. As early as 1967, the U.S. Supreme Court, in the criminal context, recognized that children who have been accused of committing crimes have a right to counsel. If I sit down and I read that decision, I think that reasoning applies to kids who are in foster care as well. You can just march through the decision, and if you substitute children who have been accused of crimes for children who are in the state's custody as a foster child, I think the inescapable conclusion is that they too have a right to a lawyer to represent them in their case, to be their advocate, and to give them a voice in their own lives, and to be able to express to the court what it is they want to see happen to their cases. Unfortunately, the U.S. Supreme Court has never had an opportunity to address this question, and the lower courts are a mixed bag. We've got some really great decisions out there finding that kids do have a right to counsel. There have been a handful of courts where they've said no, kids do not have a right to counsel. So I really approach this first and foremost as that rights issue. But as that right is enforced, everything that Natalie said in her introductory comments is just so true, that it's got to be implemented in the right way in a very thoughtful approach to ensure that kids do have the highest possible quality representation in their cases.
Great. All right. Well, thank you for that, Tim. Let's get started with some questions. First question, Allison. What are you seeing? Legislative movement, federal level, state? What are you seeing?
So the overall trend nationwide is excitement and momentum about legal counsel in general, and a trend towards it. This is really the flames have been stoked for several years, and I think we can thank the federal government in both administrations for that. In 2017, the Children's Bureau released an information memorandum around high quality legal representation. And it was the first time they really stood firm and said, hey, lawyers are part of the child welfare workforce, and you need to be building this into your systems. From there, we saw new funding open up under Title 40 of the Social Security Act to help support child representation and parents representation, where previously only agencies were receiving that federal support for their legal representation. So think about what that does over time in a system where one party to the case is consistently showing up with funding to hire and retain and train a legal workforce, but the other two parties are not. Now we have this great opportunity for uptake and to just rebalance that so that everyone can show up to a court hearing equipped with a high quality lawyer to provide accurate and up-to-date information so a judge can make a really sound decision in that child's best interest. That funding has been utilized by more and more states with each year since it became available in 2019. Our most recent data released from the federal government shows 27 states utilizing that, but that data is itself over 18 months old, and I expect in the more recent report, which will hopefully be released soon, I think we're going to see at least 3/4 of states are utilizing it. So this is awesome. In the legislative side of things, because of this new funding, it creates a new conversations and the opportunity to implement right to counsel on the state and federal level. For many decades, advocates have tried to push this issue, but money has always been a barrier. That, oh, this would be an unfunded mandate, or how are we going to do this? Well, finally, the funding is flowing from the federal government. And as my colleague in the field, Amy Hartfeld, sometimes says, we now have the opposite of an unfunded mandate. We have a funded non-mandate. And so that's where we are trying to change things. We have seen the federal government expressed interest in pushing this forward. In the 117th Congress, a bill was filed in the Senate Help Committee, although it was not eventually passed. But that was great to see. I saw a question in the chat about North Carolina interest. One of the senators who filed that bill was Richard Burr of North Carolina. So if you are in North Carolina, I urge you to contact Senator Burr, thank him for his support for this issue in the 117th Congress, and urge him to take it up again in the 118th Congress. So that's what we're seeing in the federal level, really, momentum forward, and in especially bipartisan way, because both sides of the aisle now see that this has great research behind it. We have, Kendall had that slide at the beginning. We just have study over study showing it makes a difference. We have the funding, and we have the support from the lived experience community, most importantly, saying this will make a difference and help make the system better.
Thank you for that. And, there's clearly conversations happening related to Title 4E, not Title 4E, Title 4B, reauthorization, and what opportunities could be there. There's also this piece around litigation. And so, Tim, what litigation opportunities are out there?
Well, I think litigation opportunities abound. As Allison mentioned, as you mentioned in your opening, there are 13 states out there that don't provide counsel for children. I think all of those states could be ripe for litigation. Right now, I'm actually working on a case in Florida that asks a slightly different question, but I think it's an important one to ask and have answered. I represent two children who had actually requested court-appointed counsel and were denied, and then reached out to the Center's Pro Bono Children's Law Clinic and asked for help. And I made an appearance in their case, and that appearance was opposed. And the court ultimately said, no, I couldn't represent them, and that children don't have the capacity, and this is a 17 and a 13-year-old sibling pair, don't have the capacity to hire their own lawyer. And so we are taking that issue up on appeal in the state of Florida. And it's an important question, because if kids want help, if they feel like their voices aren't being heard, and if they can't hire a lawyer and the court won't appoint them a lawyer, what else can they do? And there's nobody else in the courtroom who's telling the court what it is that they want to happen in their own lives. So like I said, opportunities abound, and it's an interesting related question going on right now in Florida that we're litigating.
Fascinating. And I know, Natalie, you've done actually a lot of work kind of state level in Florida, as well as a number of different states. I don't know if you wanted to kind of elaborate. There's this whole, I use partial offense, but I don't know if you want to speak to that, what you're seeing in the states regarding these various proposals.
Right. As Allison indicated, over the last 3 years, since NACC has launched its Counsel for Kids campaign, we've seen legislators grappling with proposed language in bills that would guarantee legal representation. So we've seen success in some of those bills, and we've just seen consideration and vibrant, robust testimony in some states where there's still consideration and a lack of understanding. I think in the states where there's the most consideration and grappling, there is trouble dealing with the understanding of youth capacity. So when I say capacity, actual ability, competency, youth credibility and ability to add value to court proceedings and provide input to an attorney, much like what Tim mentioned in his Florida matter. The other things that we hear about at the state level are states grappling with funding, resources, and actual human resources. There's attorney shortages in most public defense spaces, and that's no different in the child protection dependency spaces. So we hear legislators and active stakeholders addressing those issues of child competency or capacity, dealing with workforce issues, and just overall, there sometimes in certain states is just the idea that it's not appropriate for the young person to participate in court because it would be harmful to them. That's something that I've heard stated. So those are the sort of background issues that we're dealing with at the state legislature in places that are considering these issues. And so the need for education and the need for communication of existing research, like the research that you started us off with, is ever so important for these legislators. But we still see each year there are bills passing we see each year that there are proposals being made. And so the trend is toward expanding access to client-directed legal representation at the state level.
In fact, right, like, I mean, New Hampshire is that's a market shift with this proposal. It's a step total. I mean, it's not for all youth, but clearly they're kind of propping the door open there with that discretionary appointment and then the group home appointment. Why the group home? Have you
Yeah, so New Hampshire had some litigation in the past that focused on the rights of disabled children, children in institutions. And so this was kind of something that was a byproduct of that litigation because that particular claim, the right to counsel, was dismissed. And so advocates believed it was ripe for inclusion in a proposal this year. And that's why it's so limited. But New Hampshire is not the only state that is, taking a subset of the foster care population. We see that with bright line ages, where states are selecting a group of kids that are believed to have be best suited, have the legal capacity to engage with an attorney. We also see in Alaska in 2021, they amended their child in need of aid rules, Rule 12.1, to allow for legal representation of children in certain categories. And so we see states taking an incremental approach to expanding for reasons that they they are addressing state needs and state recognition of issues. So every state is finding kind of a different way to do that. And that is what naturally happens when there isn't, a Supreme Court case or federal law providing guidance to the states.
Yeah, that's interesting. It comes up. I think they're always playing a little tower defense, if you will, on the issue when we have it for all children in the various states. Tom, you touched on it. I know there's a question too I want to address. You've seen implementation of right to counsel change the system response. There's also this issue. I mean, we heard it actually from policymakers in Missouri were very outspoken about wanting system accountability. So who holds the attorneys accountable? Who holds the child welfare system accountable? How's that work?
Well, ultimately, it's got to be the state bars have to hold their attorneys accountable for making sure that they're meeting their clients' needs, because under the ethical rules, the attorney-client relationship between an attorney and a child is supposed to be as close to a normal attorney-client relationship as possible. So that means just as if you were representing an adult in, say, a divorce or a tort matter or something, and you didn't speak to them for 2 years of the case, well, they could complain to the state bar about you. And I think the same holds true for children. Granted, they might need a next friend or someone like that to actually make the bar complaint, but the other aspect is the court's holding them accountable. One of the rules that we have, and going back to children appearing in court, is one of our new rules says judges must inquire of the child's attorney why the child is not in court. And that can be simple. That can be something as easy as when you're appearing, say, Your Honor, I represent the child. He's not here today because he's in school. But as far as the accountability goes, there is a part of that that's on the court of making sure that they're doing what they need, that they're ensuring the attorneys appearing in front of them are fulfilling their ethical duties and are actually meeting with their clients. So it's kind of a two-part system. Is the court should be doing the first level, and then where they also fail, we need to resort back to the bar, as we do with every other lawyer.
Speaking of that implementation piece, Tim, I mean, 2021 passes unanimously in Arizona, which is amazing in any state legislature in this country that something passes unanimously. So right to counsel passes unanimously in Arizona. Opportunities that you witnessed because of that change, what were those? I mean, what did it cause to happen?
Yeah, one of the big things that occurred simultaneously with the bill was a complete revamping of the juvenile court rules statewide that govern the proceeding, that governs these children's proceedings. And that was a really fantastic opportunity to make some very detailed to put into rules some very detailed requirements for the role of the child's attorney, so that, as Tom mentioned, courts and others can hold children's counsel accountable for their roles. So the rules, for example, require the attorney to meet their clients in person, and to start to develop that attorney-client relationship so that there can be trust between the client and the attorney, and so that the attorney can assess the child's ability to direct the litigation and to understand where the child's coming from, to understand what the child's goals are for their own case. And that was a really critical component. And then surrounding that was just a terrific conversation about what it means to be a child's lawyer. Prior to the 2021 bill, requiring that all children in Arizona who are in foster care are appointed legal counsel, they were appointed a guardian ad litem, and those guardian ad litems, by and large, were in fact attorneys. So this was a new role for attorneys to play in the system. And our administrative office of the courts actually hosted NAC and some of the key players in the system to have a statewide webinar and discuss this change from guardian ad litems to client-directed attorneys. And it's just been a really evolving conversation and a nice trajectory where we are seeing attorneys really engaging in these cases, developing a legal strategy, and really driving the bus, so to speak, and being the folks who are really driving these kids towards permanency and being the primary advocate for keeping them safe while they are in state care.
It's last session, we had a bill here in Arizona that made the Foster Youth Bill of Rights actually enforceable. And the same happened in Kansas last year. There's a bill in Missouri now to do that. There's a bill in Colorado. And I do think it raises that system response question, like who's going to enforce these rights? We got rights, who's going to enforce them? I think that it's interesting. Both Allison and Natalie's CASA experience, there's a question about addressing the role of CASA volunteers, attorney GALs. I mean, when I've talked about it like I initially did work in domestic and sexual violence. We have victim advocates. They play a vital role with survivors, but they ultimately can't file motions in court. So I don't know if either of you, both of you, want to share kind of maybe your thoughts on how that's changing GALs, CASA.
Sure, I can start us off. I think this is one of the common misconceptions that sometimes comes up in our advocacy for Counsel for Kids, that if children have attorneys, that they would somehow replace the role of court-appointed special advocates or CASA volunteers. That's not what we're here for. That's not what this policy is here for. These roles are complementary. And in fact, I think when you implement client-directed counsel, it creates an even greater space for CASA volunteers to dig in and do what they have historically done, which is to serve as agents to the court and provide best interest recommendations based on their trained lay advocacy. So these two things can really complement each other quite well. Another common misconception or concern we hear is, well, if young people have attorneys, are they going to ask for something that's unsafe for them or that could put them in danger? That we see that often really doesn't come to pass because of the robust client counseling that goes into the attorney-client relationship. But just to be sure that the court is hearing multiple perspectives, you can have Counsel for Kids and also have great, robust court-appointed special advocate programs in your jurisdiction working side by side. I previously worked as a best interest attorney, a guardian ad litem attorney, but we also served in the capacity as our clients' directed attorneys. We had to do both in my jurisdiction, and we had great relationships with the local CASA. CASAs were not equipped to do some of the legal pieces that youth require, like file motions or file appeals. But they could help with things that I might not have the time or capacity to do. So for example, if I had a young person who really wanted to apply for their first summer job, I saw great CASA volunteers sit down with them, help them write a first resume, help them fill out those job applications. But then let's say that the client got that job and needed transportation to get there every day during the summer. Then it would be turned over to me and I could file a motion in court to make sure that the agency was providing that transportation.
a great example. These questions, this question comes up a lot. Also, we get conflict of interest comes up a lot. And Tom, I don't know if people say, oh, everyone will be conflicted out and there'll be all these attorneys up there representing each child, but that's not really the case. And
No, in fact, I'd say we've been seeing the opposite, is that you'll have sibling groups represented by one attorney, and then they might have conflicting interests or conflicting desires. And what we've seen a lot, at least in Maricopa County, was the attorney will then move to have a GAL appointed for both kids. So now you have two attorneys in the room and two kids, but you still have a conflict of interest between the attorney representing both and then a GAL, where really what should be happening there is it should be an attorney represented for each child. So we've kind of seen the opposite problem here as more of a continued reliance on GALs, where it's not necessarily appropriate. But as far as having, an attorney for every child, we don't find that to be a problem in the criminal context. We don't find that to be a problem in the civil context. If we have one attorney representing two criminal clients that has been appointed and paid for by the state, nobody bats an eye when that attorney says, Your Honor, my two clients have a conflict and another attorney needs to be appointed for one of them, right? We don't see that as an issue in other areas of law. So I don't see, other than maybe having a local funding issue, but as far as a child's rights and their ability to be represented, fundamentally, I don't think there's really any conflict of interest issues that we don't see in other areas of law pretty regularly.
it's interesting. So like local funding, Natalie, do you get that a lot on like, we can't afford this?
Absolutely. There seems to be a belief that state legislators have to provide funding for a complete board of guardian ad litem attorneys and client directed attorneys, and that the judiciary will be responsible for appointing both to every child. And so we have lots of discussions about other options, because that's generally not fiscally sustainable. And we discuss how the client directed attorney can fulfill, the complete role, and also provide the option that Allison mentioned of the complementary roles of the CASA volunteer to provide that best interest advocacy. But definitely the funding, that comes up in the funding conversation as states grapple with how in the world they're going to try to appoint two attorneys to every child.
And some of our listeners may be curious, they're hearing best interest, they're hearing client directed, and Tim, like, don't we want every child to the best interests of the child? Like, constitutionally, isn't that what we should be doing here?
Well, I've always believed that every attorney has to have his or her client's best interests in mind as they are representing them. But the role of a guardian ad litem who's been appointed to represent a child's, quote unquote, best interests, in a sense, their client is the court, and their job is to make a full assessment of the case and to make a recommendation to the court as to what the GAL believes is in the child's best interests. But in that role, they don't have any of the typical duties that an attorney would owe to their client. So they don't have a duty of loyalty or of confidentiality or of zealous advocacy. In a sense, they're almost like a neutral third party. And the lawyer who is appointed to represent a child, like I said, I think they have to have their client's best interests in mind, but they've got a different function in the case. My friends at True North Advocates, they've got a terrific a podcast called the Children's Law Podcast, and they're constantly emphasizing that the child's lawyer at the end of the day really only has one job. And that's to recognize that they represent a client who is in the custody of the state, and their job is to get that child out of the state's custody and into a safe and loving family environment. And that should be the overriding direction of any attorney who is representing a child in the foster care system. How do I get my client out of foster care back home, if they can be reunified with their parents, or if not, to another safe and loving home and do that as quickly as possible.
Yeah, it's interesting how we sometimes miss that big point with when we're talking about this, right? It's like we want these kids to find family, but there's so much process sometimes between A and B that we kind of allow that to cloud the advocacy lane. Um, so it strikes me 10 states have client-directed counsel. So there's, is anyone on the call aware of like kind of system failure in those 10 states, like major problems in those 10 states with client-directed counsel?
Well, let's be clear. Every system is failing in the United States. There is no state that I could point to, period, and say this state has a all-star foster care system. There is no child welfare state system where I would say is better than living with family. That is not the case. And there is also no state system that has passed its federal CFSR, which is the federal audit. So let's be clear. Every system is failing in some common ways and some unique ways that might be based on their funding, their region, or just unique aspects. With that said, we have not seen any research to bear out a difference on the failings based on model of representation in those jurisdictions. We do see that when children are appointed client-directed counsel, those individual outcomes are improved. Things like permanency, kinship placement, and school stability. On a systemic level, however, those 10 states are not somehow performing systemically worse or better than others. Every state has its own challenges that they're grappling with.
Multifactorial. Did, those 10 states have it. We have this huge chasm of states that kind of have hybrid, like, where are we seeing this go? Like from an advocacy space, like, you're seeing, and Alison, you talked about kind of some federal momentum on that, but do we feel like it's moving in the direction of client-directed counsel? Do we feel like we're stagnating? What's the barometer check?
It seems to me that many of the state-based bills that Natalie's has worked on are client-directed in nature, not just this year, but also Washington State, of course, Arizona flipped, but a lot of the Colorado changed to client-directed for 12 and up. Natalie's will remember better than I do, but I have not seen a proposal since we started the campaign that would implement the GAL attorney model, but I might be misremembering.
No, Allison's correct. There's been none of the proposals that we've tracked over the last 3 years have gone in that direction. If there were existing best interest states, they were transitioning to client-directed, or if there was no right to counsel, the right to counsel that was established by law was for client-directed counsel.
So yeah, I mean, that's definitely, to me, indicates at least energy in the direction of client-directed counsel. I mean, that's one barometer, of course, to look at the bills introduced and what they're saying. I'm curious, Natalie's, what do you think child welfare advocates need to know to make progress on this? Because a number of the people who are on this call are in states that there's no bill introduced, or they're curious about wanting to introduce a bill. We're going to be launching a right to counsel toolkit later this month that we'll share kind of the playbook of how we did it here in Arizona. But what do they need to know?
Well, first, that youth input matters. And I think if you ground yourself there, then you figure out ways to amplify and support youth full participation in court proceedings, right? So youth input matters. Youth need an attorney to assist in navigating the complex legal processes, and the client-directed model is the preferred means of doing that because it helps in so many ways ensure that the young person's voice is guiding the decision-making and being considered during the decision-making. Additionally, I think any person or group that is looking to facilitate systems change needs to work on stakeholder engagement. We saw in Colorado that Colorado engaged stakeholders at multiple town hall meetings to discuss and ascertain concerns and issues and to get buy-in, so that when the bill was filed, we already had the support of all of the folks who could have come out in opposition. A lot of times in states, we see that the opposition is because they didn't get enough information, they don't really understand the proposal, just confusion. And so when you get that front piece done, where you're engaging stakeholders, it just really helps with the ultimate buy-in and implementation. And I'll speak to one more piece, that implementation piece. A lot of states need, training wheels to implement the full out guarantee of legal representation. We saw in Washington State that there was a 6-year phase-in schedule to lessen that initial fiscal impact. We saw that there are delayed effective dates. So instead of, a state might have a provision in their code that all bills are going to be effective October 1st or something, instead of having that naturally occurring effective date, having a specific effective date, maybe 12 months from the enactment of the bill, to ensure that systems have time to catch up with the change, that there's education, that stakeholders can have necessary training, and that there is a effort towards quality as we are moving forward. And I'll stop by saying this. NACC has published a manual for policymakers, seen, heard, and represented, where we include this and many other topics that really can aid the policymaker in making that transformative change for their systems.
A great resource. Thanks for giving that a shout out there. Thank you, Natalice. I want to be mindful of time. As we kind of wrap up here, Tim, you were the last kind of introduction, but I think maybe last word here to you in particular. I'm curious why you believe centering youth voice matters. You've shared with me kind of when you meet with clients or you're talking about these constitutional cases, how moved you are by the circumstances they're in and how frustrating it is the system can't see them. And so I'm curious about how, when you do your work, and when anyone who's listening on this call, when they do their work, why they care, why they should be caring so much about those youth.
Yeah, it matters to me because it matters to them. I'll tell you a quick story. I was recently contacted by a 16-year-old young man who was in a group home, said he needed help, didn't have a lawyer. I was able to sit down with him. He was a quiet, shy young man, had long hair that he kind of kept closed over his face. So it was sort of difficult to make eye contact to see what he was looking for. And I asked him to just tell me a story. And he said, I was taken from my parents 3 years ago, and I was put into this group home. I was told I would be here for 3 days, and I've been here for 3 years. He was doing well in school, and all he wanted was to go and live with his older brother, who was stable, married, had a job, was near a school that he wanted to attend. And even though he had raised this to the folks in his case, nobody had taken any action. And I was so encouraged that it didn't take a lot on our part to make that move happen. It just took a little bit of pressure, some phone calls, some pushing, never even had to appear in court or file a motion. Just had to really urge folks to listen to this young man, and to assess his brother, to make sure it was a safe place for him. And in fact, that's where he is now. And it's all because he reached out to get a lawyer's help in his case. So it matters to these youth, it matters to me, and it should matter to all of us.
Yeah, and that's what it's all about, giving children a voice. There's going to be a survey after this for you all to fill out. I want to thank this panel. I just love you all. You have such big hearts. You care about kids. You fight for them, and that's what they need, someone who's listening and who will fight for them. So thank you all, and I hope you have a great day.
Thank you. You as well.